All right, this is case number 17-125. 557. This is Prestige Financial Services Incorporated versus Angela Buchanan. The matter is set for a review on today's date. Your appearance at this time for the plaintiff, please. All right, do I have someone for Prestige here? Do I have Angela Buchanan here?
Yes, good morning, Your Honor.
All right, good morning to you, Ms. Buchanan. Have you spoken with someone from Prestige regarding this matter today?
No, I haven't spoken with anyone there. I've just been paying on the 4th of every month, like you told me to, Your Honor.
Yeah, and so you've been paying the $300 a month. I think I set this up for review to make sure that that was ongoing and to give an opportunity if either side had any problems to address it. Well, it looks like you've been taking care of the business, so I'm going to go ahead and find on review that you have continued to abide by the plan. Of course, as long as you do that, you will you'll not have to deal with any type of wage garnishment. You understand it, ma'am?
I understand. I just do have one request, if you don't mind, Your Honor.
Yeah, go ahead, ma'am.
My only request is that the 4th of the month is not conducive. I'm struggling still because of the fact everything is due the 1st of the month. For me to live and survive. If I'm just requesting maybe if we could do this the 25th of every month is the only little issue I have in getting this paid, sir. Where I don't ever have to come back.
I'll, I will amend the order commencing in the month of January, and I will allow you to make the payments on the 25th beginning in January. You understand?
I appreciate that. They're paid up for December. You have a wonderful day. I got to get back to work if you get my meaning.
Sounds good to me, ma'am. All right. I wish you well. Good day to you.
Thank you for all your help. Have a good day, Judge.
You'll receive the amendment from me in the mail in the next few days.
Okay. Thank you.
Thank you, ma'am.
Bye-bye.
Good morning, Judge. You're really way far back. We can hardly see you.
All right, yeah, there's a, so, Madam Clerk, if you could adjust the camera, I think it's supposed to go on right now. So aim it down is where you need. Down to a little bit more.
You want me to go all the way?
No, yeah. Oh, no, that's you.
Right.
Okay.
We just need you to be closer. You're too far back.
We understand.
We got you there. We're adjusting the camera. Are you able to hear me well, Madam Clerk?
I can hear you, Judge.
Madam Clerk, yeah.
Yeah,
Okay, so come to your, bring it to your left. To your left. Oh, no,
You on the other side. I don't know.
Back the other way.
You needed to zoom in.
Yeah. All right, ladies and gentlemen, you may not be able to see me, but I'm here somewhere, and I'm going to try and keep my my voice up. We're trying to make the adjustments on the camera that are necessary. And okay,
Tell Deb I'm zoom you all we need to see.
all right, there we go. And bring it down.
Is that good enough there?
Yeah, that's. I think that's Deborah, Madam Reporter.
Yep, I can't zoom in.
Oh, yeah, that's pretty good, Judge.
All right, thank you. All right.
Okay.
This is case number 20165-119. This is Consumer Portfolio versus Danielle Blair. The matter is before the court on the, excuse me 1 second. On the filing of a motion and affidavit to set aside the default. I've already ruled upon the motion. Let me see if I have Consumer Portfolio here on this matter.
David Hoff for the plaintiff, Your Honor.
All right, thank you. Good morning to you. Your P number, if you will, for the record.
84107.
Thank you, Counselor. This is case 2165119. Do I have Danielle Blair on the Zoom?
Good morning, Your Honor. Yes, I'm here.
All right, thank you, Ms. Blair, and good morning to you. So I received the motion and affidavit to set aside lead file, and that motion was denied. And there was a proof of service that the court sent out, but that was just recently sent out in the court file. And I indicated that the judgment has already been in place for some 18 months. But tell me about your the nature of your motion, man. I read what you said to the court, and there is a proof of service document contained in the court's file. That's going to be sent out to you for you to take a look at that. And if you feel that you still should file an additional motion, then I will certainly consider whatever it is that you might want to bring.
Yeah, so I have the proof of service as well. I'm not sure. I sent over the letter from my previous employer regarding that proof of service. The day that the proof of service was submitted, I was at United States Postal Service in Westland. So there's no way that I was served with that proof of service. I submitted the letter from my postmaster advising the time that I clocked in and clocked out, and the proof of service was in between that time. So unless she served me at the post office, I'm not sure what the proof of service was served to.
I've already answered the motion, and see, that's what you, I guess you want to attach that to your any new motion that you might file, because of course you didn't send that in with the motion that you filed. Moreover, ma'am, let me ask you a basic question here. Is this a case where you owe some money?
I'm sorry, Judge, you cut up a little bit. I'm sorry.
Yeah, I was asking you, is this a case where you owe some money? It looks like they're suing you because there was an indebtedness that occurred, and Consumer Portfolio looks like they purchased a debt that was related to an automobile that you purchased on the previous occasion. Is that what this is about?
Correct. The original case was dismissed. It was defaulted. And then this case opened back up, and then that's when they said I was served.
Yeah, I mean, the bottom line is that you still end up with an indebtedness situation. So if I conduct several hearings and it turns out that that you were not served in this case, then it seems to me that you're still going to end up with a case against you where you got some money that you owe on an obligation that occurred as a result of you entering into an agreement back in 2019. So
right, there's another. I'm sorry, Judge. I'm sorry.
Yeah, go ahead. Say what you're going to say, ma'am.
There's another small claims court case that I'm dealing with the vehicle, because the vehicle was actually destroyed.
Yeah, let me stop you there because that part, unfortunately, that part is irrelevant. The only case that I address is the one that's in front of me. Where there may be another case somewhere that might be a mitigating factor in terms of how you address the challenges that are associated with this case. So the claim in this case, just 1 second here. The claim in this case is with damages at $18,905. Obviously, if there's something in small claims that might mitigate that, then you'll be able to raise that at the appropriate time. So it seems to me that that if there is a basis for setting aside the default in this matter, given the fact that this is not an old debt, that this would come back and you would still have to deal with this. And so it might be a more reasonable step to figure out how you might maybe have some discussions to see if you might be able to mitigate or reduce the amount that is claimed to be owed herein, resolve this and this small claims case all at one time, and then figure out a way that you might be able to set up some type of payment arrangement to deal with this. But then again, I will still consider any motion that you would want to bring before the court. If you wanted to talk with the other side and see if there's any room to negotiate an outcome to this case, as well as resolve the underlying small claims matter, then I certainly can have you take an opportunity to talk with the attorney on the other side. If you get some traction on that, then good. If you don't, then what you'll need to do is you'll need to refile your motion, submit the the document. It did arrive in the file today, but I already ruled on this motion previously. So you resubmit that, and then I'll take another look at it. And we might need to set up an evidentiary hearing for the process server to come in and to be able to put on the record when and under what circumstances they claim that they served. So there's a number of other steps involved. But if what you're going to end up with is coming back to the fact that there was a contract that you signed regarding a motor vehicle, and that the real issue here is not whether or not there's a debt, but the amount that is being claimed is the dispute, then that might be something that you're able to work out without those additional steps. Are you understanding what I'm saying?
Yes, no, that makes perfect sense. And that's my ultimate goal is the amount that's owed, sir. So that makes perfect sense.
All right. So, Council, are you prepared to talk with Ms. Blair today and see if there is some room to address some of those issues?
Yes, sir.
All right. So I'm going to put the two of you in a breakout room and see if you can find a way to get it resolved. If not, you're going to come back in, and then I'll give you. In fact, I'm going to go ahead now and give you a new court date. Ma'am, you're going to still have to file that motion unless you get it resolved. File the motion. But I'm going to try to get you back here as quickly as we can. So I'm looking at bringing you back in. Looks like the earliest I'm going to get you here is the 17th of January. So January 17th, about 10:45, 1/17, 10:45. 9:45, I'm sorry, 9:45. And I'll generate a new notice. What I'll do is I will treat defendant's motion today as an oral motion for rehearing on the motion to set aside the default. Oral motion for rehearing, and I'll set that up for 1/17/23 at 9:45 a.m. So here's a notification to go to the breakout room and see if there are some things that can be done. And if you get it worked out, come back in and let me know something so that I can know what to do with this case going forward. So there is your notification, Council, and Ms. Blair. Just 1 second. All right, there's your notification. All right, thank you all.
Okay, thank
Thank
you.
you.
Okay, so all right, this is case number 21-153-543. This is integrated imaging, I'm sorry, versus City of Detroit. The matter is before the court. Looks like I've got this set up for a pretrial conference on today's date. Your appearance for integrated, please.
Good morning, Your Honor. Ian Coote, 73154 for the plaintiff.
Thank you. Good to you, Counsel. Court, City of Detroit, please.
Good morning, Your Honor. Chandler Ola appearing on behalf of the City of Detroit, P86379.
Thank you, Counsel. Good morning to you as well, sir. Go ahead and update me in just one moment. Counsel, on the case that I sent to breakout room, did you get my notification, sir?
I did not, Your Honor. Did not come through.
Oh, I think I gave it to somebody else. Where are you again? Let me see. Say something again.
For the plaintiff, Your Honor, David Hoff.
Mr. Huff, now you know you're gonna have to pull that car over. I'm gonna go ahead and send you to the breakout room, but anytime you come into the Zoom, you're gonna have to pull over. We can't have we can't have you driving along there, all right? I didn't know I was talking.
Yes, sir.
I thought I sent your notice to somebody else, so hopefully they will not go there, Mr. Counsel for LVNB. Hopefully he won't go there. But Mr. Huff,
Pulling over right now.
all right, good, sir. All right, I'm gonna send you a notification right away, Mr. Huff.
Thank you, sir.
All right, so go ahead and update me on on where you are in regard to the integrated imaging matter.
Yes, Your Honor.
Sorry, go ahead, Mr. Ola.
Piggybacking off from our first pretrial conference, plaintiff's discovery responses were due the day prior to our first pretrial. Due to that delay, we requested a 60-day adjournment, and as of today, we are still without plaintiff's interrogatories and requests to produce. So we are looking for another extension of discovery and probably pending a motion to dismiss.
In Your Honor, I would agree with that. It looks like from the notes, we have a bit of trouble getting a response from our client with regard to the discovery. We're still working on that. We're hopeful that we'll be able to get a response. I think 60 days will tell the tale. We'll either get the responses or we'll be faced with a motion for not giving the responses. And it'll give us an opportunity to have a heart-to-heart with our client to impose upon them the importance of responding to discovery.
All right, well, I'm certainly not fond of adjourning cases out like this case has been adjourned out. I know how difficult it can be once you've gotten the matter started, and sometimes clients don't want to come through with answers. But again, that's a difficult kind of pickle to be in. The case is older than 1 year now, I believe. So all right, I'll go ahead and set it up again. Let's see if you can get somewhere. If you need to bring any motion or anything in front of me, go ahead and get it set up in time to come back on the date that I'm going to give you, so that we can have that date as a motion hearing date as well. So I'll find that there is good cause for adjourning the pretrial conference, and I'll reset that matter over for the 13th of February 13th, 2023, and that's going to be at 10 o'clock a.m. 2/13/23, 10 o'clock a.m. And if you file a motion, as long as you give 10 days notice to the other side, I'll hear the motion on that date. So unlike the court rules, the special rule in this case applies pursuant to the scheduling order that the court set out. You file your motion during, as long as you given the other side at least 10 days notice, I will hear the motion on the 13th of February 2023 at 10 o'clock a.m.
Thank you, Your Honor.
Very well. Thank you, Your Honor.
Thank you, gentlemen. See you soon. All right, this is case number 22-192529. This is Sterling Security LLC versus Ace Petroleum Incorporated. Today's date and time set for a first hearing regarding this matter. The court is in receipt of the answer. The matter is now joined. Your appearance for Sterling Security, please.
Thank you, Brian Mark. Sterling, my P number is 47125.
All right, thank you, counsel, and good morning to you, sir.
Good morning.
Ace Petroleum Incorporated, your appearance at this time.
Good morning, Judge Nicholas Lefevre, P62897, appearing on behalf of Ace Petroleum.
All right, and good morning to you, Mr. Lefevre. I don't get to see you much, and we know why, because you're in that other busy docket most of the times, I suppose. All right, good morning to both of you. All right, so this is, of course, first hearing. And I kind of need to know where you are. Typically, of course, I'd set up a scheduling order to give you some time to conduct discovery and see where things go. Any chance that you have any room to talk about this short of that, or give me some insights into what your thoughts are, Plaintiff?
Sure. Yeah, we have Mr. Lefevre and I have talked about this case. It looks like there's some complication because the property is under, I've just learned that today that the property is under receivership. The company's not, so I don't think there's a stay of proceedings, but I do think that will complicate things. And I don't believe at this point, and certainly Mr. Lefevre can correct me, I don't think that he's going to be in a position to really work this out without maybe motion practice and that sort of thing.
Thank you, Council. Mr. Lefevre?
That is more than likely true. The property is under receivership, and that poses some complications. The company that signed the contract, plaintiff, is not under receivership. The property is. I'll discuss this for Mr. Marcus. I don't know if we're going to resolve this short of a motion for summary. Otherwise, so I'm frames. I don't see any reason to drag this out longer than necessary.
All right, got it. Yeah, I'll go ahead and set it. I think the appropriate thing here is to set it on a 60-day discovery period. And as you know, my order, my scheduling order will have contained in it the reality that you could file a motion, dispositive or otherwise, and have it set for hearing on the next date that you come back in front of me, and I will hear it on that date. The only requirement is that you give the opposing party at least 10 days opportunity to respond to your motion, and I will hear it on the next action date. That next action date in this matter is going to be the 15th of February. That's going to be 2/15, 2023, and that's going to be at 9:30 a.m. You will receive a scheduling order in the mail from me. That scheduling order will tell you that discovery is open through that day. You'll have through the 15th of February to conduct discovery. It will also, under paragraph number 6, provide that you can file motions hearing on that same day, on the 15th. And I will hear the motion on that date. The one requirement, make sure that you give the other side at least 10 days notice and opportunity to respond to the motion. I will hear it on the 15th, right? So I wish you all, gentlemen, you'll get a copy of that order in the next few days.
Thank you, sir.
Thank you. Good seeing you again.
Madam Reporter, I know that was a little bit compromised of the sound. Are you okay there?
Yeah, I was biting my tongue, but yeah, I'm okay. Now you're sounding.
This is case number, yeah, thank you. Case number 22-242568. This is Jacqueline Miller versus Red Baron Enterprises, LLC. The matter is before the court, set for a pretrial conference. I previously set forth a scheduling order in this matter, allowing for discovery through today's date, and also allowing for the filing of any motions if the parties had something that they wanted to bring before the court on today's date. Your appearance for the plaintiff in this matter, please, or do I have Ms. Jacqueline Miller or an attorney for Ms. Miller? Someone say something if you here.
Hey, good morning, Your Honor. Sean Murphy.
This is Jacqueline.
One second, Ms. Miller?
Yes, I'm here.
All right, good morning to you, Ms. Miller. Are you represented by counsel?
No.
All right, counsel for Red Garden, please.
Yeah, good morning, Your Honor. Sean Murphy, P79255 here on behalf of defendant counter plaintiff Red Baron.
All right, thank you, counsel, and good morning to you, to both of you. So I know you've had this period of discovery, and of course I noticed that there is a counterclaim that has been filed as a part of this action as well. Counsel, why don't you go ahead and update me first, and then I'll come to Ms. Miller, please.
Yeah, good morning, Your Honor. So we have exchanged some discovery. Ms. Miller had sent some out. I believe it's due today or tomorrow. We're planning on sending it out this afternoon so she can have our responses back. We recently received some documents and information from Ms. Miller. So because of that, we would ask that the court adjourn this a little bit longer just so we can have an opportunity to file a motion for partial summary disposition.
All right, so Ms. Miller, it seems that there is some discovery or information that's being exchanged between the parties. The attorney on this other side seems to be indicates that they are likely to file a motion and ask the court to set up a hearing regarding any motion that they may file. Anything you want to tell me, your thoughts regarding this matter at this point, ma'am?
Well, I gave them my, answer and my responses back in November. And then I asked them for some discovery or information that I guess, as he said, is due either today or tomorrow. I mean, as far as the 21 days, you know, well, first off, while we're doing that, you know, I filed a motion to amend in August of 2022, and I haven't received an answer or anything regarding that motion.
All right,
August 1st.
Yeah, let me check it. Let me check on. All right, I do have my hands on what the document that you filed. Council, did you receive a copy of the motion to amend?
No, sir.
No.
So did you send a copy of your motion to amend to council? The court received your handwritten document. Did you send a copy to the attorney on the other side?
No, I didn't receive an answer from the court.
Well, let me ask you the question again. Did you send a copy of that document that you filed with the court? Did you send a copy of that to the other side, to the defendant?
No, I didn't. I was under the assumption that I would get it back from you.
No.
And
No, if you file something, you have to notify the other side of what you're filing, so they have a chance to respond to it if they want to.
oh, okay.
That's the issue here. And I noticed that I was in the process of responding to this on August, sometime in August. I had this in front of me and I was in the process of writing a response to it. And when I noticed that that it did not look like a copy had been sent to the other side, and so that's why I said I will wait until the hearing. I'm glad you brought it up. I said I'll wait until responding to this because it didn't look like the other side had received notice of this. So what I'm going to do is I'm going to see the best way to get this done. Just one moment. All right, so what you sent to me, ma'am, it was a package that had attached to it your answers to affirmative defenses. It also had a motion. It had certain letters attached to it. It has a Federal Trade Commission article attached to it, items along those lines. Is that correct?
Yes, I did send that. However, the motion, I came in and filled out and paid the $15. You know, all of that.
Let me stop. I know that. What I'm trying to get is that it seems to me that when you filed the motion, you attached those other documents. Is that true, or you just filed the motion without? I
just filed the motion.
Let me stop you. No, the reason I'm stopping you is because I want to try to assist you by my office sending out a copy of your motion to defendant's counsel.
Okay.
I just wanted to know what you had attached to that. I see that there are other items that you submitted to the court, but of course, before the court could answer this motion, the other side has to have an opportunity to respond.
Right.
So what I'm going to do is I'm going to adjourn this matter to allow the discovery process to get completed. And you'll get an adjournment notice in the mail in that regard. And with that notice, counsel, and I'm going to make sure that Ms. Miller gets a copy of what she submitted as well. With that, I'm going to send a copy of the motion the motion to amend that was filed with the court, so that I can hear that on the next action date as well. And that'll give council an opportunity to respond and write to that document. What do you have to say, Ms. Miller?
Okay, with you adjourning it, I need you to know that I can't come in January because I'll be out of Michigan.
All right, well, hopefully it's an enjoyable trip out of Michigan. I wasn't gonna put it in January.
Oh, okay.
It's gonna be in February, just based.
Okay,
on
good.
all the stuff that I have going on. Okay, so I'm gonna, let's go ahead and set it up for you to come back on the so I'm gonna bring this back on the, let's come back on the 15th of February. So 2/15, 23, and that's going to be at 9:45 a.m.
Okay,
9:45 a.m. So you'll get a document in the mail from me with that new that adjourned date on it, and you will also get a copy of the motion that was submitted to the court. And then I'll hear that motion on that date. And council, if you file a motion and give Ms. Miller at least 10 days notice, I'll hear that motion on the 15th as well of February.
Okay.
All right. All right. I wish the two of you well, and I will get these documents out to you. That we put in the mail today, so you get it in the next few days.
okay, I appreciate you.
Okay.
Thanks.
Thank you, Your Honor. Have a good holiday.
Likewise. One second. Mr. Huff, are you here?
I sure am, sir.
Okay, and I see Ms. Blair is there as well. Any updates at this time?
Yeah, we had a good conversation, Judge. What I think we're going to do in the meantime is do an agreed garnishment, reduce the monthly amount that comes out of her paycheck to a total of $65 per pay period. And in the meantime, she's going to continue to talk to her insurance company, work on the small claims action against the guy that hit her, wrecked her car. And I'll get touch base with my client. So I think right now the issue is the wage garnishment and the amount. And we've agreed to that $65 pay period. Of course, pending any further motion for relief that Ms. Blair files.
Ms. Blair, is that about about the size of the discussions that were had today, ma'am?
Yes, and then I don't know if this also needs to be on record, but regarding the interest that's on the amount as well, something that Mr. Hoff said that he's going to speak to the client regarding.
Correct. Well, private discussion with my client, see if they'll waive any interest and help compromise, settle the claim.
Yeah, I mean, I think that it sounds like to me that that's a part of the global discussion that was had, that there's some efforts to do any offsets that might be agreeable in terms of reducing balances and things like that. So so the starting place, it seems that with your discussion that you all have been successful at reducing any type of garnishment at this point. And Mr. Huff, are you going to submit something in that regard, or sign something that would make that happen?
Yes, what I would certainly like to do is I could submit an agreed garnishment order, or an agreed reduction, agreed order reducing the garnished amount, get your signature on it and send it over to Ms. Blair's employer.
Right, and that's why we're still talking here on that part of it. So I do have an order that I will address. You work for DTE Energy, is that correct, ma'am?
I do, yes.
All right, so I'm going to go ahead with regard to that document, and I'm going to release any funds withheld to the plaintiff. and the garnishment withholding is going to be reduced. And the reduced amount is going to be 65 per pay period, is it?
Correct, Your Honor. And I believe Ms. Blair is paid bi-weekly.
Yes.
Okay, so I'm signing an order that's saying that, and I will send that out. I'll get that out in the mail right away. And then, of course, Ms. Blair, what you'll want to do is take that to your employer so that they can do the proper deduction. You understand?
Yes. Thank you so much, Judge.
All right, I hope the rest works out well on both sides. All the best to you. You have, I think I had a control date, but you're coming back in January.
January 17th.
All right. So you'll get a notice of that date as well. So I wish you well. Good day to both sides.
Thank you, Your Honor.
Thank you. You too.
Just one moment, everyone. Right with me. Number 06136291. This is Focus Hope versus Tyrone Bivens and Joyce Bivens. The matter is before the court on the following objections to a writ of garnishment by Ms. Joyce Bivens. This relates to the Michigan Department of Treasury. The record should reflect that a judgment was entered in this case initially in 2007 for $4,303. That judgment was renewed subsequent to that time on September 23rd, 2016. The plaintiff seeks to collect upon that judgment. Your appearance for Focus Hope, please. Focus Hope. All right. Do I have Joyce Bivens on the Zoom? Joyce Bivens, if you're on the Zoom, please say something at this time. Just one moment. All right, it appears that the petitioner has not appeared regarding this matter. And for that reason, the court will find that the objections are invalid and any funds withheld will be released to the plaintiff. Record should reflect further that in the petition, the defendant has indicated that she receives Social Security as her sole source of income. To the extent that that is the case, then no funds will be subject to garnishment under those circumstances. The defendant is not here, and so the court cannot drill down on those issues.
I'm here.
The court calls now case number 0711853. This is LVNB Funding LLC versus William Suttles. The matter is before the court on the following objections to a writ of garnishment regarding the third-party withholding unit of the Michigan Department of Treasury. The record should reflect regarding this matter that a judgment was entered for $1,398.86 in 2007. That judgment was renewed subsequent to that time, and the plaintiff seeks to collect on the outstanding balance. The renewal date was August 29th of 2017. Your appearance for the plaintiff in this matter. LVND Funding LLC. Do I have someone appearing on this matter? Do I have Williams Suttles? Say something, Mr. Suttles.
I'm sorry, Your Honor, what's the case number you called up again?
This is 0711854, LVMV Funding versus Williams Suttles.
Okay, I'm here for LVNV, but that's not a case I'm assigned to, Your Honor. I apologize.
Okay. All right, Mr. Suttles, say something. Good morning to you, sir. Yeah, you're on mute. Hit your microphone or *6, Mr. Suttles, so I can hear you, sir.
Can you hear me now, Your Honor?
Yeah, good morning to you, sir.
Good morning, Your Honor.
All right, so you filed the objection to a writ of garnishment, and you said that the funds are properly exempt as a basis for your objection. Looks like you got an outstanding judgment here. What do you mean by the funds being exempt? Tell me about that.
I just now got this letter. This is the first one I had. They said they've been sending me out letters, a collection, and I had paid all my collection people off before I got a loan from the bank. I don't know where this come from.
Well, it certainly, there certainly is an outstanding judgment that you have against you here at the court. It was entered in 2007, and then it was renewed in 2017. And I don't know what the exact balance is, but the judgment and entry was $1,398. So that judgment is outstanding. That gives the plaintiff the right to pursue collection by way of filing a writ of garnishment against the state of Michigan withholding. So that's what's going on with this. If you are attacking the underlying judgment, you do have a right to file motions to try and undo the judgment, but it has been in place for let's see, 2007. So now we're talking 16 years or so. Well, approximately 16 years. Go ahead, Charles. Listen to you.
Your Honor, this is my first notice I got ever.
Well, you're gonna have to go back and find out what may have happened, because what you're dealing with now is you're dealing with post judgment. This is collections. If there's something that you believe that happened where this should not be in collections, you got to go back and file a motion regarding the judgment that was entered. Like I said, that judgment was entered initially in 2007, and that means that back then in 2007, something was submitted to the court demonstrating that you have been served, that you have been the documents have been given to you in 2007, and therefore a judgment was entered. And the records that I have does say that that judgment was entered by default, which means that there was not a response. Subsequent to that time, the record shows that several garnishments were attempted over the years in 2009, 2010, 2011, 2012 and 13, etc. And then the judgment was renewed in 2017, and then there are attempts to collect on the judgment since that time. So this has been going on for that entire period of time. And yeah, it's been going on for that. So you do have an outstanding judgment. Do you work for the state of Michigan, sir?
No, sir. No, Your Honor.
You do file taxes. You receive a tax return, correct?
Not at this time, Your Honor.
Okay. Yeah. Well, if you don't receive a tax return from the state of Michigan, then it would not affect it. It would not affect you in that way. Where it would affect you is if you win the lottery or something like that, then they would be able to get their money. If you won the lottery, they'd be able to lean on any assets that would come through there. So I don't see a valid objection. You may be able to file something to try and get the judgment set aside. But like I said, that's been 15 years. But you could still try to do that. But as far as the garnishment is based upon that judgment, and that judgment is still valid.
Yes, Your Honor. They garnished me and they took $1,220 out of my bank account.
When was that?
That was what? They took my money out about 2 months ago, Your Honor. Joint account, me and my wife joined the account. They took $1,220 out.
Okay.
But they didn't put it down on the paper.
Okay. So did you get any paperwork illustrating what the balance might be? Because you're addressing another problem, and that is that with the judgment being in place for 15 years, you got interest accruing on that.
Yes, I
But
understand.
if you paid money on it, that's a big chunk. That's a big chunk to pay on it, and but you still likely have a balance because of how long it's been sitting around.
But
Right.
I didn't know this resisted because I had, like I say, at my bank, I went to my bank and they gave me everything I needed to clear up before I get a loan, and I cleared up everybody. And I don't know where this came from. I paid off everybody.
Yeah, and that would be the kind of thing that you would want to if you got proof that you paid this off, then you want to file that in some type of motion saying that the judgment has been paid off. That's the key thing here, is that you got a judgment and I don't have any evidence that it's been paid off. And you just mentioned to me a big payment, so that you would have to get credit for that. But I don't know what the balance is. So there would still be some type of balance involved in this. And that's why
Yes, it is.
this garnishment against state income tax return, that's why this garnishment can be made, is because there's still a balance on that judgment. Right?
Yes, the balance is more than the it's 116 and I didn't owe but 12. Now they got me paying, they want 1,300 and then they want 1,600 in
Yeah,
interest.
That's interest. You may want to call the Weber and Oseet's office to see if you can talk with someone about setting a particular amount as a payoff number and trying to close this out.
I tried that.
Okay. Well, then you know what your only other option is, because the only thing that I'm addressing today is this motion that's in front of me. The two questions that I have to deal with: one, is there a judgment in place? Number two is whether or not a garnishment can be issued on that judgment. Those are the two issues I'm dealing with. It sounds like there may be a lot of other issues that you want to address, and you may address those issues by filing something against the judgment. You may file like a motion to set that judgment aside or something along those lines, and bring all the paperwork that you have to bear, and then I'll consider all of that. But today, the only thing that I'm addressing today, is there a judgment? Is there money outstanding? And the answer to that is yes. And because that's the answer, then the objections would be invalid. Now, again, the extent to which you say you don't have any money coming from the state, then this will be a moot question, because if you don't have any money coming, they can't get anything. All right.
Yes.
So I wish you well. That is my determination. You'll receive a copy of my order regarding this matter. It looks like you keep looking over at somebody. Is that your wife or?
That was my wife going by.
Yeah, that's the money person. I understand. I got a wife too. So all right. Well, you get a copy of my order, and again, you do have the right to file other paperwork and try to address this, Mr. Summers. I wish you well, sir. Good day to the two of you.
Thank you, Your Honor.
The court now calls case number 16-111654. This is Modern Financial Services Corporation versus Natasha Crossley and Travis Thomas. The matter is before the court on plaintiff's motion to set aside the, I'll strike that. The matter is before the court on the objections to a writ of garnishment regarding the third-party withholding unit at the Michigan Department of Treasury. The record should reflect in this matter that there was a judgment that was entered, and that the balance on that judgment seems to remain outstanding. Your appearance for Modern Financial, please.
Good morning, Your Honor. Naljat Francis on behalf of Plaintiff's Attorney of Record.
All right, thank you, Ms. Francis. Your P number, if you will.
Sorry, P72322.
All All right, so it looks like the judgment was entered in 2016 for $5,878.89. Do I have Natasha Crossley here, please?
I'm here.
All right, good morning to you, Ms. Crossley.
Good morning.
All right, you filed your objections here. You said the funds or property is exempt from garnishment. If there's an outstanding balance, then they certainly could file a garnishment against the Department of Treasury. What do you mean the funds are exempt? Talk to me. Tell me what you're trying to tell me.
When I would, well, when I had went down there to file, the only thing that was on there was something about the bankruptcy proceedings, and the person that was helping me was telling me to get to stop the garnishments. I have to let them know. With the one that I picked, they were just telling me that I had to let them know that I'm not getting anything, like I'm not working or anything right now, and that's the only thing that I was going to get was my taxes, and then for them to garnish all of my taxes, like I need some money.
All right, well, you know,
I have a whole child. I got a 6-year-old daughter that I have to take care of.
Gotcha. You know, this does not affect federal or state, a federal income tax return. It would affect any state withholding. You understand that?
Oh, no, I didn't know that.
Yeah. So if you got a federal return, this does not garnish federal return. This would it would affect the state tax return. You understand?
Okay.
Okay. So you thought it was both of them?
No, I just thought that it was just taxes, period.
Oh, I see. All right. So how much money do you anticipate from the state of Michigan?
I have no idea. I haven't really worked or anything this year. My earlier this year, my grandmother was diagnosed with stage 4 cancer, so I had to stop everything and take care of her. I lost my house and everything, so I'm kind of in the bind right now.
You're saying you didn't earn much last year, correct?
No, I didn't. I didn't really work. Didn't have a chance to.
All right. It sounds to me that this is almost a moot question. I don't see a valid objection, but it seems to me that if you're not going to be getting anything from the state, then there's nothing much that can happen to you too much. Let me talk to Ms. Francis. Ms. Francis, anything at this time now?
Your Honor, I would agree that with what you said, the court rules don't give, unfortunately, an objection just because you can't afford it. So she has not stated a valid objection, and we would ask for her objection to be denied.
Yeah, Ms. Crossley, if you were dealing with a situation where your wages were being garnished, there might be a situation where we would then say, well, maybe we'll set up a partial payment and get that garnishment off your wages. This is a garnishment against the prospect that you might receive a tax return from the state of Michigan, a tax refund. If you receive, the plaintiff would have the right to intercept that, or if you hit the lottery, they would have the right to get their money. If you hit the lottery, any money that the state might process on your behalf as taxes or winning of lotteries and things like that. What you've stated, as honestly as you stated, it just doesn't provide a valid objection to the garnishment. So I will release any funds withheld, although it looks like there may not be any funds withheld. So it may, like I said, be a moot question. You'll receive a copy of this order, and like I said, it does not affect federal tax return anything, just a state tax return.
Okay.
Wish you well. You get a copy of the order from me in the mail in the next few days, ma'am. Good day to you.
Okay, you too. Thank you.
Thank you, Madam Counsel.
Thank you, Your Honor. I'll see you in the other courtroom.
Yeah, I know. We'll try to get there. Okay, thank you. All right, this is case number 18-15-0029. This is LVNV Funding LLC versus Leona Humes. The matter is before the court on the filing of objections to a writ of garnishment. Again, this is in regard to the Michigan Department of Treasury, and the court has reviewed the objections, the defendant points out she did not know about the matter. All right, your appearance for LBND funding, please.
Yes, Your Honor. For the record, Eduardo Polaris, P 63559 on behalf of plaintiff.
All right, thank you, Mr. Polaris, and good morning to you, sir. Thank you for your patience. Didn't know where your file was. We finally got to it down here. All right.
No problem.
I'm looking for Ms. Humes, Leona Humes, if you're on the Zoom, say something at this time. Leona Humes, if you're on the Zoom, please say something at this time. All right, it looks like Ms. Humes has not appeared regarding this matter. And the only the objection that was raised is that she did not know about this matter. There is a judgment that's already been entered by default, and also a motion that was filed with me by Ms. Humes. That motion was filed back in 2021. So I don't know what she was saying that she doesn't know about this. The key thing here is that I don't see a valid objection to the garnishment. Counsel, anything you wanted to say at this time, sir?
Judge, just adding to your observations, we have been in contact with the defendant numerous times on this. She did indeed file a motion to set aside the default that was denied in 2021. She's filed a Consumer Financial Protection Bureau complaint. She's made several disputes with our office. So not only is there no valid objection listed, what she indicates in her motion is not accurate. She was well aware of this judgment for quite some time.
All right, now, once again, I'm looking at Leonard Humes. I was saying Leona, Leonard Humes, last name Humes, or file says, yeah, Leonard Humes. Again, no response. I will find that the objections are invalid. I don't see any valid objection. And for that reason, any funds withheld will be released to the plaintiff at this time. So ordered.
Thank you, Your Honor.
Thank you, Counsel. Good day to you.
Good day.
The court now calls case number 21-159, LBA Funding LLC versus Rosemary Brown. The matter is before on the filing of objections to a writ of garnishment. This is regarding third-party withholding unit in the state of Michigan. The defendant has filed objections indicating that for LBNB funding. Do I have someone for LBNB funding? If you're on this Zoom, please say something at this time. All right, do I have Rosemary Brown on this Zoom? Say something if you're here.
Yes, I'm here. Can you hear me?
Yes, good morning to you, Ms. Brown.
Good morning.
So I reviewed your objections. You know, the challenge here is that there are two types of garnishment. One is a wage type garnishment, and then there is the type of garnishment that's like a income tax withholding, bank accounts, et cetera, et cetera. And if you have a installment order in place, it does not prevent those other kinds of garnishment. It does prevent someone from intercepting your wages if you're paying under an installment agreement, but it does not prevent a garnishment against against your tax return. It doesn't prevent a garnishment against your bank account. So tell me what you want to tell me at this time, ma'am.
Well, I'm paying them as much as I can. I'm not working. And, you know, they already have this on my credit report. So it's really messing my credit report where I can't even do anything to try to pay it off. So I'm paying them as much as I can. And so that's why I'm under objection to this, because you know, you're going after the taxes and then you gonna start going after something else. And I mean, I'm doing the best I can here.
Well, the challenge, I think, as you know, the challenge here is that the law allows that. It allows for the enforcement of the judgment in several different ways. Now, let me ask you, you said you're paying what you can. Do you have an agreement with them regarding a payment plan?
Yes, I do, on both accounts.
I'm sorry, say it again.
On both accounts.
Okay, yeah, so I only have this one in front of me, but I don't have any document in the file that demonstrates any payment agreement that was filed.
Yes.
Before. So
What?
I don't have anything, I don't have a court order for you to make installment payments, so you must reach some agreement to make a payment to the company, correct?
Yes, with Steiner and Steiner, you know. And I made agreement. I paid them every month for those two accounts. I haven't missed any payments or anything.
All right. Well, see, part
So I've already.
Go ahead, ma'am. I'm sorry.
Yeah. So I'm, you know, I know what you just said, but I'm, you know, I'm not working or anything, and I'm just paying them as much as I can. And, you know, I just don't need this to go any further because, you know, just, like I said, it's on my credit report. And even though I'm still paying them.
Yeah, I mean, but that's as horrible as it is. And a lot of things I disagree with about debt and debt collection. I mean, all of that is awful. And so, you know.
I'm sorry, I didn't quite hear you.
I said, yeah, I don't like some of that either, but all of that is lawful. It's lawful that if there is a judgment that can be put on your credit report, if you're and that you could be paying a voluntary payment that doesn't prevent the plaintiff from pursuing it by way of going after things like bank accounts and tax returns. So this would affect your state income tax refund. It does not affect any other things like federal.
Okay, well, you know, if they don't get anything from tax, then they're going to try to sue other areas as well.
That technically can be the case. The law allows them to do that. So, for example, the key things that you look at when there's a judgment issue, first thing that could happen is that they could file a petition to seize, to take certain stuff. That's not happening in your case. It doesn't look like that. That's something that they've ever expressed any interest in doing. But short of that, there are a few avenues that are typically explored. One is to try to garnish wages if you're working. Two, to go after a bank account if you have money in a bank account. Three, to try and get money from the state of Michigan if you have a state tax refund. And then, of course, filing that document with the state of Michigan is a way. If you don't have anything coming, the key thing that they're doing here is to put a notice there that if you win the lottery or you win some money with the state, that they would be able to collect it from that. That's why this particular document is filed. So it sounds like you're not expecting a tax return.
Well, I'm not working. That's why, you know, when I'm paying them, that's all I can afford right now.
And let me stop you. You know, you already told me all that, okay? And I've listened to you. You told me all of that. Here's the big thing for you to think about. If you don't have any money coming from the state, then this really is a moot question. They can't get any money from you if you don't have any money coming. Now, if they file something else, then you want to respond to that. But if you don't have any money coming from the state, you know, you could talk to me about that 16 different times. Now, if you know that you're getting $5,000 back from the state, then the conversation that you need to have with me as judge, can you send $1,500 to them and make sure that the rest come to me? But if you ain't got no money coming from them, you understand what I'm saying? That's the only issue today.
Yes, I do.
Okay. Now, if they come after you for something else, then what you do is the same thing here. You file something and come to court and say, Judge, they're coming after my bank account, and I have the $3,000 is all I have in that bank account, and I know I owe them some money. But Judge, can you pay them $1,000 and give me $2,000 back? Whatever. That's the kind of argument you want to make. But there ain't no money. They're filing paperwork, hoping that you hit the lottery. That's what this is, okay?
Okay.
So, you know, the objection that you mentioned is invalid. But again, the biggest thing that you got here is that if you don't have any money coming, this is a moot question, okay? You'll get a copy, of my, my order, in this regard, ma'am. I do wish you well on this.
Okay, thank you.
All right, thank you. All right, this is case number 53. This is Goldman Sachs versus Erica Wilkes. The matter is before the court on the filing of a motion for summary disposition. I think I set it on for a pretrial date, and yet there is a motion that is pending for hearing on this date as well. All right, your appearance for the plaintiff in this matter.
Yes, thank you. Good morning, Your Honor. Attorney Jason Brain on behalf of the plaintiff, Goldman Sachs. My P number is 69653.
Counsel, good morning to you. For defendant in this matter, your appearance at this time, counsel.
Good morning, Your Honor. Aaron Ogletree, about for Ms. Wilkes, and she's present as well.
All right, thank you, counsel. Your P number, if you will, Mr. Ogletree.
69-16-7.
All right, thank you, counsel. All right, and good morning to you as well, Ms. Wilkes. So the motion for summary disposition in this regard.
Your Honor, before you go into it, there have been a settlement reached in this matter.
All right, thank you, Mr. Ogletree, for saving me some breath. It sounds like you're a long way from me in terms of digital geographic distance. So I'm like hearing you through a tunnel a little bit. All right. So it sounds like there's some indication that the parties have reached a resolution in this matter. Somebody go ahead and tell me what that's about, or what engagement you would like from the court at this time.
Okay. So, Your Honor, Mr. Ogletree is correct in what he is saying. We did reach a settlement in this matter, and a consent judgment outlining those terms was mailed to the court on December the 7th. It was signed by both parties, and our office is the one that had mailed it out. And all that said, at this time, in light of that consent judgment being mailed to the court, plaintiff would respectfully request that our motion for summary disposition be withdrawn at this time.
Makes sense to you, Mr. Ogletree?
It makes sense. If the court is interested, I guess we could recite the terms of it. But,
no, you know, so long as what I heard Mr. Brainerd say is that both counsels signed off on it, and the terms are pretty clear and set forth and already mailed off. So
yeah,
that's it. Now, one of the things that you could do is you could email that document to me, and I could get that signed off right away, because I know with it being mailed, I don't know how long it's going to take to actually populate to the file. So if you email it, I'll get it right back to you.
Okay, certainly. It sounds good, Your Honor. What's a good email address for you?
Now that's gonna be Carmen, CARMEN, dot, last name is Banks, BANKS. That's at 36360th at 36districtcourt.org.
Okay, Your Honor. I've got Carmen.banks at 36districtcourt.org.
That's correct.
Okay, we'll go ahead and email that over your way, and we'll CC brother counsel on that email as well.
All right. Sounds good.
Thank you. Happy holidays. Take care.
Yes, happy holidays to you, and all the best to you, Ms. Wilkes. Good day to you, everybody.
All right, thanks so much. Happy holidays. Take care, Your Honor.
She had an audio app. She could hear everything, but we wasn't able to. But she had just received something in the mail.
Yeah, tell her she received something in the mail. Tell her she was, what she put on here is that she receives disability. They can't collect her disability. They can't take this. Okay. Okay.
You have to zoom in the same way, but you're going to zoom in to 534 instead of 336.
Who's this stupid?
Yes, Ms. Bill.